India Legal presents Courts Roundup.
Hello, I am Tanya Chugh and you are watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here are the headlines. Judge of Andhra High Court passes order with critical observations against the proposals made by the Supreme Court Collegium. Matter relates to transfer the Chief Justices of High Courts of Andhra and Telangana. Kerala High Court quashes rules brought by the Kerala government to regulate sale of other state lotteries, holding the state government lacks such a power. Hearing case on allegations of intercaste couple being threatened by Jharkhand Minister, State High Court provides for safety of couple, sends order copy to Chief Minister. Talking sarcastically and taunting daughter-in-law is part of married life and cannot be a ground to seek custody of aged in-laws, observes a Mumbai court while granting anticipatory bail to the in-laws.
India Legal presents Courts Roundup.
Underlining that National University of Study and Research in Law is a prime institution of the state of Jharkhand, the Jharkhand High Court recently conveyed its sentiments to the state government that the university needs regular support of the state government.
The Jharkhand High Court has stressed that National University of Study and Research in Law needs governmental support. The bench of Chief Justice Dr. Ravi Ranjan and Justice Sujit Narayan Prasad specifically observe it is high time that the state government should think over it, that for every small or big expenditure, the Vice Chancellor of the university should not be compelled to move. The matter before the court was related to the work of encircling the plot which lies on the other side of the road of the NURSL building with a boundary wall to avoid its encroachment. This work is to be done with state's assistance. Filing a counter affidavit, the government told the court that it is very much eager for development of the NUSRL, Ranchi, and has taken already steps for the same. To demonstrate the same, it stated that provision of 70 crore rupees has already been made and the process of releasing the sum to NUSRL has been initiated. It was also submitted that government is also positive for contribution in development of NUSRL Ranchi. The court remarked that the university, like the other universities and various other national law universities in other states, cannot thrive on the revenue collected through fees deposited by the students for its development and meeting the routine expenses. The court said, like other universities, certain grants on a regular basis, monthly or yearly, should be given by the state of Jharkhand. For example, there is a provision in the Patna University Act regarding meeting the budgetary expenses from the consolidated fund of the state. Importantly, the court said the state government should come up with a policy for such type of support to the institution, that this institution is beneficial for the state of Jharkhand, especially when we have been informed that 50% of the seats in the university has been reserved for the candidates of the state of Jharkhand. Bureau Report.
In view of serious allegation against a cabinet minister of the state who allegedly threatened an intercaste couple, the Jharkhand High Court recently directed that copy of its order along with the copy of the statement of the women be communicated to the Chief Minister of the state. The bench of Justice H.C. Mishra and Justice Rajesh Kumar was hearing a habeas corpus petition filed by the husband praying for direction for production of the corpus before the court. Women married out of their free will and started to lead conjugal life according to their choice. Thereafter, they were threatened, women married out of their free will and started to lead conjugal life according to their choice. Thereafter, they were threatened and harassed by the family members of the girl, who were not agreeable to the relationship as the husband belonged to a different caste. Eventually, somehow, they got the girl in their influence with the intention to separate the couple, and thus the husband knocked the doors of the High Court. Having perused the Registrar General's report and after interacting with the couple, the court was satisfied and was convinced that it was a fit case in which both the parties be allowed to live together and the petitioner be asked to take his wife along with him right from the court itself. At the same time, the court also noted that due to illegal interference in her conjugal life by her family members and maybe also from highly placed political person who is presently a cabinet minister in the state government, the perception of threat of couple may be genuine. The Kerala High Court has quashed the rules brought by the Kerala government to regulate sale of other state lotteries, holding that the state government lacked such a power under the Lotteries Act 1998, which is passed by the Parliament.
The Kerala High Court has given a verdict on regulation of other state lotteries. The court held that no state can exercise its authority by making rules in such a way to impact upon authority of other states to organize, conduct and promotion of lottery. The power is exclusively given to the central government under Section 6 of Lotteries Regulations Act. The central government alone has the power to regulate, control and interfere with lotteries if it is run in violation of law. Observe the judgment delivered by a single bench of Justice A. Muhammad Mustaq. The verdict came in a writ petition filed by an agent selling lotteries of the state of Nagaland in Kerala. The petitioner challenged the amendments brought by the Kerala government in 2018 to the Kerala Paper Lotteries Regulation Rules 2005, which gave power to Kerala government authorities to regulate and control lotteries run by other states. On an examination of various provisions of the Lotteries Act, the court came to a conclusion that the rule-making power of the state does not extend to interfering with the sale of other state lotteries when the state itself is engaged in lottery business. The power conferred on the state government is a delegated power. The Parliament alone has exclusive power to make laws with respect to lotteries. The court noted that the power of the state government to prohibit lottery sale under Section 5 can be invoked if lotteries are totally prohibited in the state. In other words, the state government cannot selectively ban other state lotteries when it is running lottery business. The power to interfere with other state lotteries is only to extent of prohibition of sale of lottery tickets. The court declared that the petitioner has every right to sell and market the lotteries organized by the state of Nagaland and the state of Kerala. The state of Kerala has to be restrained with the right of the petitioner to market and sell the lotteries organized by the state of Nagaland, the court said. If sale of any lotteries is carried out illegally, only central government can intervene in the issue, clarified the court. The court also clarified that if the sale of Nagaland lottery is carried out without following the instructions of the central government, the Kerala government can approach the centre. Bureau Report.
Moving on to the next story. Justice Mohammad Fahim Anwar of Madhya Pradesh High Court has dismissed the bail application of a man arrested in connection with the cow slaughter under MP Govan Se Vadh Pratishat Adhiniyam and MP Agricultural Cattle Preservation Act. The court said the charge is very serious. In such cases, giving the benefit of bail will adversely affect the society, the judge said. During the hearing of the case, Advocate Manish Meshram appeared on behalf of the applicant Zahir Siddiqui, a resident of Seoni. Advocate D.P. Patel opposed the application on behalf of the state government. Advocate Manish Meshram argued that officers of Danda, a police station in Seoni district, arrested Hamid alias Jagga before the arrest of the petitioner. He was loading cows into vehicles and carrying cattle for agricultural work. A sharp razor was recovered from his possession. On searching properly, chopped pieces of cattle were found. This shows that cows have been harmed. Jagga confessed to his crime and took the name of applicant Zahir Siddiqui, after which Zahir was also arrested. Advocate for the applicant further argued that since the applicant is in judicial custody from August 10, 2020, so the benefit of bail should be given. The High Court rejected the bail application after considering the whole matter. The court clarified crime registered under sections of MP Governance Vade Pratishat Adhiniyam and MP Agricultural Preservation Act is serious in nature. In a curious development, a judge of Andhra Pradesh High Court has passed an order with critical observations against the proposals made by the Supreme Court Collegium to transfer the Chief Justices of High Court of Andhra Pradesh and Telangana. In an order passed, Justice Rakesh Kumar sought to draw a connection between the transfer proposals of the Supreme Court Collegium and the bombastic letter shot by the Andhra Pradesh Chief Minister Jagan Mohan Reddy to the Chief Justice of India with allegations against the state judiciary. While adding that he was not raising any questions at the Collegium proposals, Justice Kumar observed that transfer of High Court judges or its Chief Justices may reflect some transparency. After all, they are also holding constitutional posts like member of Honorable Supreme Court Collegium, he added. Justice Kumar observed that by sending unceremonious letter to the CJI, the Chief Minister has succeeded in getting undue advantage at the present moment. These observations were made by Justice Rakesh Kumar while rejecting an application made by the state government, seeking his recusal from division bench hearing a case. The Advocate General alleged in the application that Justice Kumar had taken a biased stand against the government. It was alleged in the application that Justice Kumar made an oral observation during a previous hearing that we will declare there is a breakdown of constitutional machinery in the state and hand over administration to the central government. Certain newspaper reports were annexed with the application to support the allegation that the judge had made such oral remarks. However, Justice Kumar denied making any such remark and said that he was merely expressing doubts about the legality of the move of the government to auction public land for private bidders. He rejected the allegations of bias and came down heavily on the government for seeking his recusal. Our report. Talking sarcastically and taunting daughter-in-law is part of married life and cannot be a ground to seek custody of aged in-laws, a Mumbai court said while granting anticipatory bail to the in-laws accused of cruelty under Section 498A of Indian Penal Code. The court was hearing a plea by Ramesh and Malvika Dalal, applicants seeking anticipatory bail in relation to an FIR filed by their daughter-in-law, alleging offences under sections 498A cruelty by in-laws, 420 cheating, 406 criminal breach of trust and 506 criminal intimidation of the Indian Penal Code against them and their son. Special POCSO Judge Madhuri Barelia observed that apart from offences alleged, the rest of allegations made in the FIR against the applicants are of general nature. The court also noted that the complainants stayed with the applicants only for a very short period. Further, the investigating agency had already frozen their accounts. Investigation was ongoing and there was no necessity for continuous custody of applicants, the court said. The complainant daughter-in-law submitted that there was a probe pending against the applicants with the International Consortium of Investigative Journalists, which had frozen their accounts. The court, however, was not impressed by that line of argument since the present FIR was an independent crime. The court therefore directed the applicants to surrender their passports to the police station while allowing them the anticipatory bail. In an order of significant import, the Punjab and Haryana High Court held that life and liberty of live-in couple has to be protected even if one of the partners has not attained marriageable age.
Punjab and Haryana High Court has given an important order related to live-in couple. A single-judge bench of Justice Alka Sareen therefore remarked that the society cannot determine how an individual should live her or his life, especially when the individuals were major. Since the right to choose a partner is a fact of the right to life, the life and liberty of a live-in couple should be protected, Justice Sareen ruled. The court was hearing a petition filed by a couple who alleged that they were being harassed and threatened by the woman's family on account of the relationship. The two intended to marry each other. but chose to be in live-in relationship since the man had not yet attained the minimum marriageable age. The two were, however, majors. The High Court placed reliance on Supreme Court judgment on Shafin Jahan versus Asokan KM, popularly known as Hadia case, to underscore that every individual has been guaranteed the right to life under the Constitution, with the choice of a partner being an important facet of the same. Therefore, there were no legally justifiable reasons for the family and relatives of a live-in couple to object to their relationship, the High Court concluded. Though the court refrained from remarking on merits or the legal validity of the relationship between the petitioners, it directed the police to take necessary steps and consider the couple's representation for security. The non-attainment of the minimum marriageable age was not an impediment to seek protection of life and liberty, the court reasoned, especially since they were both major. The court also made it clear that parents could not dictate terms in their adult children on how to conduct their life, and that individuals were entitled to live as they chose provided they did so within the contours of the law. Court said that parents cannot compel a child to live a life on their terms. Every adult individual has a right to live his or her life as she or he deems fit. The court, however, emphasized that it had not adjudged on the legal validity of the relationship in question. On these terms, the petition was disposed. Bureau Report.
The Delhi High Court has stated that a private or other government doctor's opinion, which is contrary to that of the doctors of armed or police forces, cannot be accepted to determine the medical fitness of a police force aspirant. The court was dealing with a petition preferred by an aspirant to the post of constable in the Central Armed Police Forces. The petitioner was declared medically unfit at the stage of medical examination. The petitioner questioned the conclusion of the Review Medical Board by submitting an application to the competent authority in Central Reserve Police Force. She contended that there was no specialist in Review Medical Board and that she had been wrongly declared unfit. The court noted that the petitioner had no convincing answer with respect to her source of the information, that the Review Medical Board had no specialist. The court further observed that the standard of physical fitness for the armed police forces and the police forces was more stringent than the civilian employment. It added that a contrary opinion of private or other government doctors could not be accepted as the recruited personnel are requested to work for the forces and private doctors or the government hospitals are unaware of the demands of the duties. The court further added that the government would also be saddled with a police force where personnel would seek soft postings because of their health conditions and low medical category. The National Green Tribunal has refused to close the Oversight Committee and extended its term for 6 months and directed the state of Uttar Pradesh to put forward its suggestion while hearing the matter pertaining to monitor the pollution of River Ganga and sand mining activities around other rivers in the state. The Oversight Committee is constituted on the suggestion of the state of Uttar Pradesh by the tribunal for a period of 6 months, which was subsequently extended at different intervals. The basic functions of this committee are to monitor pollution of River Ganga, rejuvenation of River Hindon and associated issues, sand mining at Allahabad, pollution of thermal power stations in Singrauli, pollution of Ramgarh Lake and River Ami in Gorakhpur, solid and biomedical waste management norms, etc. A bench headed by NGT chairperson Justice Adarsh Kumar Goyal has further requested the committee to monitor compliance of directions to oversee preparation of district environment management plans and their execution by the district environment committees. On the basis of recommendations made by the OC, NGT has directed the district magistrate Prayagraj to take further steps in the matter and maintain surveillance. The issue of compensation, if not already finalized, may be finalized with the assistance of the CPCB and the report should be furnished to Oversight Committee. The National Company Law Tribunal Principal Bench has passed an order directing a resolution professional to not proceed a resolution plan in a corporate insolvency resolution process after an issue with respect to rights of landowners came up before it. The order was passed by two-member bench of Acting President BSV Prakash Kumar and Technical Member Hemant Kumar Singh. Under the terms of collaboration agreement, the corporate debtor was to develop the land at its own cost and expense, including the expenses for obtaining the requisite approvals, licenses, etc. In lieu of the consideration of the land, the corporate debtor agreed to provide certain sum of money to build a permissible constructed area and hand over the same to the landowners under the terms of collaboration agreement. However, the collaboration agreement was vitiated by efflux of time as the corporate debtor did not perform the obligations. Thereafter, the landowners filed civil suits before the district court against the corporate debtor. Meanwhile, the NCLT admitted the insolvency petition against the corporate debtor. Certain landowners thus moved by the NCLT, asserting that the corporate debtor was unlawfully trying to proceed with the invitation of resolution plans in respect of their land. The landowner stated that the application was not maintainable in eyes of law as the RP could not ask a creditor to fill a claim in a particular class. That's all for Courts Roundup. Thank you for tuning in. Keep watching APN.
India Legal presents Courts Roundup.